Good afternoon, and today is Monday, January 25th, 2021. It's 5 days since the presidential inauguration and the transition to one-party control of Congress. It's also about 776 days since Kathy Kraninger took over the CFPB and has now departed. So welcome to Consumer Financial Services Outlook 2021, Post-Inauguration Day Insights. My name is Jonathan Pompan, co-chair of the Consumer Financial Services Group at Venable, and I will be today's moderator as well as also a panelist on occasion. In the wake of major changes in Congress and a new president, our webinar today previews what's on the horizon for consumer financial services law and policy and outlines the year ahead. We're joined today by my partners and colleagues, Andy Arculin, Allison Baker, Laura Biddle, Andrew Biggert, Alexandra McGarris, Sarah Donovan, and Chris Scribner. But first, some housekeeping. Today's session is going to be recorded, so please know that there'll be a recording available and sent to you later this week. We're also providing CLE, and so later today, there's going to be a code provided. Now, we're also using Zoom, so there's a Q&A feature, and if you have questions, please feel free to send them. We're going to do our best to work them into the conversation. And also, if we don't get to your questions, we will attempt to answer them after today's presentation. Now, of course, contacting us and asking a question doesn't create an attorney-client relationship. And while you may have some detailed questions, please don't send us confidential information. So again, today's CLE code is going to be provided halfway through, as well as at the end of today's presentation after the close. So please stay tuned for that. Now, there's a new president and Congress. There's also changes at the agencies. There's a regulatory update we'll be providing, and there's no shortage of regulatory developments from the prior years that may certainly impact 2021 and beyond. We're also going to be discussing supervision, examination, and enforcement today. New posture, new tone. Many people say it's a reinvigoration of the CFPB's enforcement shop, and certainly we're even seeing that in the states already. And we're going to do a brief look at the states. Now, all of the topics that we're going to cover today are ones that we could do hour-long presentations, if not longer, on probably every slide and every facet that we're going to be discussing. So today's a thumbnail sketch. And to get us started, we're going to transition now to my colleague, Senior Policy Advisor Sarah Donovan, and also Chris Scribner, both of our government. Sarah, there's a lot of developments today, and there's certainly no shortage of newspaper articles on any number of topics. All of us, for so many reasons, are following what's happening in Congress and with the presidency. But I think it's important that we at least set the stage for what is really a new period. Again, it's now just only 5 days, but certainly many years since we've had a democratically controlled administration. And now we've got single control of Congress. What does this all mean, and who are the players?
Thanks a lot, Jonathan. Chris and I will be talking about all of those things during our presentation. And of course, we'll get into some of the more specifics as we go through. But just to set the stage, on the in the House, Speaker Nancy Pelosi remains in charge of a very narrow Democratic majority. What's interesting here is that while Democrats sort of, we say unexpectedly lost ground here, I think the common thinking was that there would be an expanded Democratic majority in the House, and that actually contracted somewhat. So she's got a narrow majority to work with, and she has some group of House members on her left flank that she also has to watch. Now, she's an adept leader, and she's very good at keeping her caucus together. So we can probably expect them to vote as a block, but she just has such a slim margin of error here. So this slide here shows that there's 2 still unseated or uncalled. We've got one seated with 6 votes out. This is Miller Meeks. And the race that's outstanding in New York is still going through the court system. Which votes they're going to count, what is ultimately going to be decided there is unknown. There's a 19 vote spread right now, and there's several thousand votes that still need to be, the judge needs to determine whether or not they'll be counted. We don't know who those votes are for. So all that is to say, House is in Democratic majority control, but it's a narrow one, a more narrow one than last Congress. And in the Senate, we have a very interesting situation here too. So the Senate is divided 50-50 with Vice President Harris as the tie-breaking vote. So what does that mean? Well, Senator Schumer and McConnell right now are negotiating a power sharing agreement. When you have an evenly divided Senate like this, you have to reach some sort of resolution to determine how the Senate will be organized. And that resolution is going to require 60 votes in order to pass. So it's going to require bipartisan cooperation. What we're hearing directly from members themselves, and this has been reported well in the news as well, that the basis of this resolution we expect will be the agreement that was reached in 2001. And in that case, the committees were evenly divided between Republicans and Democrats. And the chairman in this case are going to be Democrats, and tie votes will advance to the floor. So they're going to have some mechanism for these logjam in the committee to actually proceed further. Here we've got a list and some pictures of some key committees of jurisdiction for those that are on this webinar today. There's a lot of familiar faces, although there's a few new ones that we should point out. So Speaker Pelosi, as we mentioned, is still in charge of the House. And the House Financial Services Committee has the same leadership that it did before on both sides of the aisle. What's different here on the House side is that Kathy McMarsh-Rogers from Washington State, she's replaced Greg Walden as ranking member on the House Energy and Commerce Committee. And we included this because Energy and Commerce has jurisdiction over the FTC, so we included both Commerce committees here. And also they've got within their purview, they're the primary committee of jurisdiction for issues like privacy. And while the banking committees will have the piece of privacy that affects the GLBA regulated entities, there's still a relationship between the efforts that'll happen on the Commerce Committee with regards to privacy and financial services companies too. So we just wanted everyone to be aware. Here, the working relationship between Pallone and Rogers is still somewhat unknown because she was, not in leadership on the committee last Congress. But from what we've heard from his staff, they have a great deal of respect for Rogers. She's considered, to be someone that you can work with. And I think going into this Congress that there's a lot of good feelings between the two. So all good news. On the Senate side, we have Chuck Schumer as the leader. He's right now effectively the Senate Majority Leader, even though we haven't had that organizing resolution. So interestingly enough, I didn't mention this on the Senate slide, but the committees in the Senate are actually technically still under Republican control because the committees have not yet been organized. So it's a little bit of a strange situation over there. We expect that to be resolved, somewhat quickly. But here on Senate banking, we've got a new face, Patrick Toomey, who is retiring this year not this year, in 2 years. And that means he's sort of a free agent. He's already been very outspoken against former President Trump. He's sort of unleashed in this case because he isn't running again, and we'll have to see what he has in store. And then on the Commerce Committee, we have the same leadership that we did last time, Senator Cantwell and Senator Wicker. I think it's pretty well known that they have, not the, greatest working relationship. And I think that's mostly due to personality differences. But I think they both have committed and have said as much that they're committed to working together and seeing what common ground they can find going forward.
Now, there's a lot discussed in the press about what the Democratic Congress can do versus what some spoilers or swing votes might impact. Certainly, Chairman Maxine Waters, and Sherrod Brown have no shortage of opinions as to what should be happening in the consumer financial services regulatory space. Sarah, Chris, what's actually feasible here for folks to think about in terms of what the Senate and particularly the House, but really the Senate, which will be the spoiler, can accomplish on their own. And certainly in a moment, we're going to get into a lot of what really the Bureau and others, even the FTC, can do without Congress taking the lead. But Sarah?
Sure. So we've got it pretty, I would say that the range of motion in the Senate is limited, but they still have quite a bit that they can accomplish with this, divided Senate. So without the 60 votes that's necessary to overcome a filibuster, like we mentioned earlier, the day-to-day operations of the Senate, any legislative activity, it's going to require Republican cooperation. So similar to in the past when it was flipped and the Republicans were in the majority, you really had to see bipartisan support for things to move forward. But there's a number of things that Democrats can do by themselves with Vice President Harris as a tie-breaking vote. One of the things that's pretty significant is they can confirm the Biden nominations. This includes both executive and judicial. The reason is because this only requires a 51 vote majority, simple majority to do those things. Another thing that they can do, and we'll talk about this, I think Chris is going to cover it just a little bit later, that's CRA. And that's where they're able to rescind Trump administration, quote unquote, midnight regulations using the Congressional Review Act. And that's certainly something that we could see them employ. Another thing that they can do, and there's been a lot of talk about this in the press, and I assume, this is one of the things you wanted us to really, you want to have us talk a little bit more about, Jonathan, and that's the budget reconciliation process. You can do a lot in tax and mandatory spending changes through that process. So I'll just spend a few minutes here and talk a bit about it. Congress can pursue one budget reconciliation per package for each annual budget, one reconciliation package for each congressional budget resolution for each year. So they have not done one for 2021. They also have one available for 2022. They've actually got two opportunities in which to make, to pass these. An identical resolution must be passed by a simple majority in both chambers with specific instructions to the committees of jurisdictions on what fiscal targets they must reconcile to. So committees must then pass their respective pieces, and the budget committee is going to bundle that together into one package, and that'll be considered by the full chamber. Now, there's a number of policies and provisions that this process must adhere to. We call that the Byrd Rule. Some of those it must have a significant budget impact, and it can't lose revenue beyond this 10-year budget window. So theoretically, the majority could override the parliamentarian on this, but that is not expected in this case, and is considered the quote unquote nuclear option.
So it's possible, Sarah, for instance, while we're going to talk about the substantive policy agenda that Congress might take up in just a moment, there's certainly like COVID relief and other spending, tax and spend related aspects of the U.S. budget, federal budget, that where policy riders essentially could kind of move along with it. So folks in the audience should keep an eye on that to the extent that they're looking at congressional activity. The budget debate, which is probably started last Wednesday, really is going to be something to keep their eyes on, is right?
Yeah, I think the Democrats' strong preference is to have COVID-related measures go via the regular order process. They do not want to use that budget reconciliation for those things. They want to preserve it for things like, taxes, healthcare, things like that. But yes, absolutely, policy riders could travel along with this, and we'll be keeping a close eye on that as well.
So let's talk a little bit more now about Congress and consumer finance. What's on tap there?
Yeah, thank you, Jonathan. To underline the point that Sarah made, I mean, the biggest policy making move that the Congress will make this year, and it's going to come from the Senate, which is in the nominations process. So the ability to shape and to pick and to allow President Biden to pick his financial services team will be the kind of paramount role that Congress plays. There's certainly an expectation, some of this because of our belief that the filibuster is going to remain and a 60 vote threshold will remain, that it will be difficult, to pass banking bills, which historically have been, difficult to pass, whether, whichever party controls Congress since Dodd-Frank. But if we look at the priorities of, the two chairs, I mean, you'll see that at the top of the list for both, they're going to be focused on pandemic relief, that is their number one priority. Pandemic relief can include housing and rental assistance as part of the package, forbearance, which can have an impact on consumer finance issues. Last year, at the when it was expected that Senator Brown was going to become chair of the Senate Banking Committee, he said that his top three priorities were housing, housing, and housing. So we see a kind of consistent agenda across the two committee chairs. I would note, in terms of sort of their ability to run their committee or to pass bills, Waters can do it on a simple majority basis. She can, and the House can be more active in passing legislation, but we don't expect to see legislation that, even if it gets out of the House Financial Services Committee, even if it potentially gets out of the House, to get through the Senate. But a couple of the other kind of broad themes that both Waters and Brown have touched on are issues tied to lending discrimination, which, if we think about an overall Biden theme of economic inequality, dealing with economic inequality, financial inclusion. At the end of last year, Senator Brown, for instance, introduced the Fair Access to Financial Services, which was a kind of anti-discrimination measure. Again, a messaging bill tied to social justice aspects of policy. Where the most noise will be is the ability to hold hearings, to shape the rhetoric, to call regulators and to ask them in front of the committees and to ask them to take action. But consumer finance is expected to, or consumer finance policy is expected to move primarily through the agencies and not the Congress. And just to underline that point, both Waters and Brown are on sort of on the left wing of the Democratic caucus in each. For Brown, he is really, I would say, out of step in many ways with the moderate Democrats who will be key to be passing bills. So as we look at some of these core themes, again, it's the executive branch activity. Again, driving the nomination process where we see Biden getting his full choice of nominees. That's important in the CFPB, as I think, as we, now that's not a question of whether or not Chopra will be approved by the Senate. We will have, if you've read the press, you've seen that the progressive wing of the Democratic Party will not be happy with all of President Biden's nominees. They're unhappy with the floated idea of Michael Barr to lead the OCC. And that probably has to do in some measure with the fact that their favored nominee, Mirza Baradaran, who is also Senator Brown's favored nominee, has a focus on financial inclusion, a focus on economic inequality, pushes forward leaning on an issue like postal banking, something that Michael Barr is not front and center on his agenda. He's an experienced regulator, but he fought some battles of in the Dodd-Frank era, made concessions, and progressives are looking back at that behavior and criticizing it. So it's a significant shift from from kind of Democratic unity on nominees, but we think there will be Democratic unity overall on pushing for an active and aggressive CFPB, for instance. In terms of rolling back regulations, and we expect that to be a regulatory shift in the agencies, will Congress use the Congressional Review Act? Probably somewhat sparingly. This is a law that allows Congress to look back at legislation passed 2 months before the end of an administration and to essentially rescind and annul regulation on that topic. And that is one reason why Democrats who don't want to keep the agencies from regulating on a particular topic will be reluctant to use the Congressional Review Act. There's one OCC issue tied to essentially commercial bank lending, also called fair access, but very different from Brown's fair access proposal. But it really says banks can't keep from lending to a segment of the industry. Think of issues related to social issues, guns, climate issues, which are going to be front and center in the regulatory agencies, energy companies, and saying banks can't make a blanket decisions not to lend to a particular industry. So we do expect that Congress will help shape the rhetoric, but the real action in the next 2 years will be in the regulatory agencies.
Thanks, Chris, and thanks, Sarah. The Congressional Review Act is definitely one we get a lot of questions on. And in fact, there's questions around whether or not Congress would use the Congressional Review Act in light of the fact that if something is rescinded through that process, substantially similar rules can't be promulgated by the agency. But of course, Congress could also make that determination as to what is substantially similar. While there could be some litigation around that, the reality is that Congress acting in unison with Democratic administrative agencies will probably work it out as to which direction they want to go, Congressional Review Act or using a rulemaking, or perhaps just policy shifts through supervision and enforcement when it's available. And to bring us to that, certainly there have been no shortage of changes at the agencies already, with acting directors at many, as well as also nominees already for all of the major agencies. So with that, we come to the CFPB and Consumer Financial Protection Bureau, of course, front and center. You had Richard Cordray transition then into Mick Mulvaney, and then Kathy Craniger, really the second official full-time director, served a little over 2 years. And now you've got an acting director and a nominee in Rohit Chopra, who not only used to work at the CFPB, was also most recently an FTC commissioner, really advocating for higher civil money penalties at every point he could, as well as also taking a tougher stand on industry. Allison, what does the shift at the CFPB mean in terms of its posture for rulemaking, enforcement, supervision, and everything else it does?
That's a great question. Good afternoon, everybody. So I think Rohit Chopra coming in to run the CFPB is a very interesting development, really, for two reasons. First of all, Mr. Chopra's approach to consumer finance is definitively more aggressive than certainly Director Craniger's was and Director Mulvaney's was. Two, and this is something that I think gets lost a lot. Rohit Chopra is not a lawyer. He's an MBA, and he worked at McKinsey, and he has a very thorough understanding of how the CFPB, when it first came online, was really designed to be a multidisciplinary agency. Its approach to consumer finance is really multidisciplinary insofar as it deploys policymaking, rule writing, supervision, and enforcement. It isn't just an enforcement agency. And indeed, a lot of its founders conceived of the Bureau as being as much about economics, as much about policymaking, as much about being data-driven with statisticians. And I think you're going to see a return to some of that DNA. Rohit was the first student loan ombudsperson at the Bureau. He was very effective at leveraging the CFPB's specific mandate and working to the extent he could with the Department of Education. He understands that interplay, and I think you're going to see him take that understanding and really apply it in a much more comprehensive way across a lot of different offices at the Bureau, not just enforcement. Don't get me wrong. I think enforcement is definitely going to be amped up. I think you're going to see a lot more investigations and probably some more litigation that comes out of that. But I don't think that's all you're going to see. And in fact, I think you'll see a lot more deliberateness around other types of tools, if you will, in the Bureau's toolkit that are definitely contemplated in the CFPA.
Yeah, and Alice, that's a really good point. Anybody who's been around Rohit Chopra knows that he's really not only thinking about things in a multifaceted way, but he's inquisitive by nature and looks about inputs and outputs. He's talked a lot about the role of private equity in the non-bank consumer finance space. He's talked a lot about the role of investors and the incentives for investors that then can lead to debt collection or investment loan issues. He's not just focused on what's happening on the ground, but also what's happening behind the scenes on Wall Street and elsewhere. Andy, you worked at the Bureau at the same time as well as Allison when Rohit was there. Any thoughts about that with respect to rulemaking? And I know we're talking about rulemaking a lot in just a moment, but certainly, with the Bureau being a sole director, has an outsized influence.
Sure. So again, thanks everyone for tuning in. I hope everyone can hear me well. So something we'll see with Rohit coming in charge, Rohit Chopra coming in charge, is what I call bringing the band back together, meaning a lot of the folks who were there during the Cordray administration will be returning to the Bureau. A lot of folks who feel like, the agenda that they had in mind for the last couple of years was put on hold, and now is an opportunity to bring it back. I'm foreshadowing a little bit. I wouldn't be surprised to see the Bureau take things like small dollar lending back up, even though that's been sidelined for a while, almost to the point where the rulemaking was killed. It was not killed the same way that the arbitration rule, also a Cordray administration rulemaking, was killed by the CRA. So there's some more flexibility there, and I think what's going to change the most fundamentally in my mind is the Fair Lending Office. As you may recall, when Mulvaney was in charge of the CFPB, Patrice Ficklin, her Office of Fair Lending was put directly under the director. It was no longer the Office of Supervision, Enforcement, and Fair Lending. And I believe, Patrice and her office they have a lot of work that they wish they'd been doing for the last couple of years that they will resume, and I think resume aggressively with Rohit in charge of the agency. And that spans everything from mortgage lending, and that, especially given the fact that CFPB changed the HMDA reporting rules. There's this gold mine of data that's just sitting there in a database about mortgage lending practices and pricing, to servicing practices, to auto lending, all of these areas that I wouldn't say they've been ignored. Obviously, institutions have been going through examinations, but there haven't been the big ticket investigations and enforcement actions that we saw when Cordray was there, and I do think that will all change. I also think there's some rulemaking initiatives that we'll get into in a couple of slides. Another area, though, that's not directly rulemaking is Military Lending Act. That's an area where the Craninger administration took a view that the CFPB may not have authority to supervise for Military Lending Act compliance. I expect that to change, as well as many other things.
Now, not only is the CFPB a major player in financial services, supervision, regulation, and policymaking, but at least on enforcement, the FTC plays a role, and certainly the FCC is of influence too with respect to advertising and marketing practices through telecom. So, briefly, you got at the FTC, it's a real interesting scenario because you have a situation now where the FTC's authority to bring civil money penalties in certain cases, so the consumer relief, is in question, as heard before the Supreme Court, and is something that could ultimately be a litigation hazard for the organization going forward. Certainly, Congress could make a shift, but Rohit Chopra, actually, in one of his last dissenting opinions, in addition to saying all sorts of stuff about what should be done in the debt collection space, specifically called out the fact that the CFPB and the FTC should be coordinating more, and in part that the FTC, to the extent that it can't get its work done in a way that is good for consumers, in his view, should really be shifted more over to the CFPB. And so we'll see that play out probably within the next year. Certainly the Supreme Court case will come out. In the meantime, Rebecca Slaughter's going to be the chairwoman of the FTC, and you'll have probably a fairly active docket in all its areas, including financial practices, based on consumer complaints. That's always been the track record there. Their latest statistic, always around 90% of the cases they bring or enforcement actions that they bring relate to consumer complaints. And that probably won't change, but perhaps the magnitude might even shift more to where you see the CFPB continue to be the dominant player on the bigger ticket industry shifting cases. So at the FCC, one point of note, just to be on the outlook for, there's a case pending now before the Supreme Court that will decide what an auto dialer is. And of course, there's no shortage of regulatory action around FTCPA generally. And for those that text or use an auto dialer, those are areas of pain and pressure and perennial legal work and regulatory observations. And that probably will not change in 2021. So at the banking agencies, Laura, I know that there's, again, changes there. And those changes affect a lot of the issues around bank partnerships and fintech. What's on deck there?
Thank you, Jonathan. And again, thank you all for joining us today. I think when we look at the agencies themselves, Chris had mentioned a lot of things will happen if they're going to happen in the banking system. It's going to happen at the agencies, given what Congress is dealing with right now. And as he said, the comptroller is up in the air right now. At the FTC, the chairwoman McWilliams, she is her tenure term doesn't expire until 2023. Although he said she may be leaving a little bit early, so there could be things coming out of the FDIC, but probably a little more limited, particularly given the new FDIC board that she will have. And at the Federal Reserve Board, things probably a little more stable, given the fact that Powell and Clarita's terms don't expire till 2022. And so I don't think we'll see any noticeable shifts there. But I think what we do see will kind of have a theme coming from the administration and Congress that we've sort of talked about so far throughout, the first being financial inclusion. Safety and soundness will also be an issue, particularly for large banks, given the fact that there was a perceived rollback in enhanced prudential standards in the last couple of years. Climate change, again, not just in terms of safety and soundness and the risk that it poses to the banking system, but also social responsibility. And we may even see in as far as Community Reinvestment Act goes, the possibility of CRA credit for loans and investments that promote disaster preparedness and climate resilience in LMI communities. So bringing that into some of the more social aspects of the regulations. And then fintech, as you mentioned, Jonathan, it's not going away. But I think we'll be wrapped up with financial inclusion and consumer protection. The new administration and even Congress doesn't want to be seen as stifling innovation, particularly because that innovation often is a benefit for financial inclusion and the underserved.
Well, that brings us to getting into the weeds, a regulatory update. Andy, there's no shortage of docket items that the CFPB has pending. And interestingly enough, versus reality, was actually fairly effective in ruling that the consumer groups wanted it to always go. But they got a lot done. We're going to talk a little bit about debt collection in a moment, but besides debt collection, what else is on tap and what could be on tap for the future?
So thanks. This is the last published rulemaking agenda that the CFPB put out, and this was from last fall. Obviously, some of this is going to change. You can see there are some rulemakings like debt collection, qualified mortgages that have already been finished. There's some in the pipeline like small business data collection, which is very important, potentially groundbreaking, depending on how it's done. CFPB has been more in the study phase on some of these rulemakings, the pre-rulemaking stages, but they'll be moving into the rulemaking stage. And on top of that, and we can go to the next slide, I just have a list of things that I think may potentially change. As I mentioned before, the small dollar payday lending rule has been sitting there, depending on who you ask, it's basically been rolled back to the point of almost being non-existent. That could come back. We're not sure yet. A lot of this will depend on who's in charge of the CFPB's research, markets and rulemaking office, my former office at the CFPB. There's been a rulemaking on the shelf for overdraft protection that hasn't gone anywhere the last couple of years that could come back. the small business data collection rulemaking could be much more detailed and, as again, depending on who you ask, intrusive or thorough, under this new leadership. And there's a lot, there's a specter of fair lending, I think, behind a lot of this, and that will be a renewed priority. On top of it, there's a number of policy initiatives that aren't necessarily rulemaking, but they're also not enforcement or supervision. There's COVID related. There's continued efforts to hone down on Regulation X and the servicing rules for loss mitigation and those sorts of things. CFPB has done some rulemaking in that area already, but now there's a conversation about broader disaster relief that's not specific to COVID, and it's more long term. I mentioned fair lending a few times already. There's also UDAP, how the Bureau views the abusiveness prong of UDAP and so on. So a lot going on the rulemaking front. With respect to specific financial products, mortgages, and consumer lending, and we'll also get into payments in a little bit with Andrew Biggert and others. The ability to repay rules have been changed. Those take effect over the summer. I mentioned the COVID-related rulemakings, and something that we'll have to just keep an eye on as we talk about fair lending more and more, and as that becomes more important, is this expanded data field that exists that that mortgage lenders or originators have been reporting into for the last several years. There may be when there are changing priorities like this, the statute of limitations on the enforcement statutes does not change, right? So there's a record that's there that has not been harnessed yet by the CFPB that very well may. I also expect some areas of focus for the Bureau will be in areas like alternative underwriting, target marketing, which do bring up fair lending and discriminatory practice issues a little less directly than we're used to seeing in credit decisioning, but that will be an area of priority moving forward. And on consumer lending, Laura talked a little bit about Fintech. Obviously, Fintech is an important area. The other banking agencies, not the CFPB, have done rulemakings around these issues of True Lender and Madden, which have been around for quite some time. The OCC, with respect to national banks and federal savings associations, has been very clear on the true lender aspect, which I think is the most difficult for fintech companies to get right and to process. The FDIC's taken a different view. They've actually, and I'll invite Laura to join the discussion here. To date, at least, they've actually taken the position that the FDI Act does not give them the authority to define whether a state bank has originated a loan or not, whereas the OCC has been far more specific. And Laura, any thoughts you have on that topic?
Yeah, and I actually understand that. The OCC is the chartering agency for national banks and federal savings associations, so it can make the decision as to what the activity entails, whereas the FDIC really is just the primary federal regulator for state chartered banks, and so states primarily are subject are subject to the laws of the individual state, whether it be loan limits or when the actual loan is made. Presumably, that's how they're thinking.
Thanks. And one thing I neglected to mention just real quickly, with Rohit being in charge, former student loan ombudsman, student loan servicing is another area that looks to increase in importance. That's an area where the CFPB has been largely hands-off the last few years. I know Allison will talk about that when we get to enforcement trends, but another area to watch.
And now my partner of 15 years, Andrew Biggert, on payments.
Great. Thanks, Jonathan, for that. And I'll also probably be joined by Laura to talk a little bit more about some of the chartering issues that are definitely important for the payments industry. But over the next few slides, we'll run through a bunch of topics. Payments is obviously a kind of a diverse industry where you've got bank issues, you've got payments companies and money transmitters. And so we want to make sure that we hit on topics that will be relevant for the next year. The first is early this year with the National Defense Act. There were new Bank Secrecy Act, anti-money laundering rules that came into place. A lot of different issues, just to highlight two of the most relevant ones. The law set up a new beneficial ownership registry that will be housed within FinCEN that can be used by banks and other financial institutions for their customer due diligence obligations. This is a big change. The beneficial ownership rule requirements only came into place a few years ago. A lot of payments companies had to really hustle to change their onboarding and diligence processes in order to comply with that. And the hope is that this new registry can make that easier while also providing a lot more information for FinCEN and other federal regulators. The other big change too is a formal recognition that an entity that engages in the transmission of cryptocurrency is a financial institution under the BSA, and then therefore going to be subject to the requirements that come along with that. Another issue that's been also percolating for a long time is the concept of faster payments. And we're getting closer and closer. There are a number of different competing models out there. You've got the clearinghouse with their own real-time payment network. The card brands, Visa and MasterCard, have been coming out with push-to-card services that function very similar to a faster payments and are often used. One of the big use cases really is paying gig workers more quickly. And NACHA has same-day settlement. And then finally, the Federal Reserve is continuing to develop its FedNow service to also provide faster payments. And I think that with President Biden, probably see support to kind of ramp up some of that, in particular the concept of being able to use these services to get more services out there to the consumers. Another area that has been a constant focus of federal regulators, and we would expect to remain so, is law enforcement looking at payment processors in particular and holding them responsible where they've assisted and facilitated the unlawful conduct of their merchants. Just in 2020, there are at least half a dozen FTC settlements, and we'll expect that really to continue. It's a lot of the same issues that we've been watching for the past several years, where the processor is alleged to have, supported bad conduct by merchants by trying to hide chargebacks or helping a merchant hide behind multiple different merchant processing accounts. So those continue to be an area of concern for the federal regulators. Some of the same high-risk industries also in terms of the types of merchants that are receiving services, work from home, business opportunities, and continuity programs still get a lot of scrutiny. One development last year that got attention was a settlement that the FTC had with one of the largest payment processors, but it was really focused on the processor's oversight of its independent sales organization partners. And the settlement agreement there really pushing a lot of third-party oversight concepts, what you might have expected to see more in traditional banking, to the payments industry. So we continue to think that that will have repercussions moving forward. Next slide. One thing that Jonathan mentioned earlier in the presentation was the Supreme Court case AMG Capital Management versus the FTC, which is looking at how the FTC has been using its Section 13B authority under the FTC Act. This is of particular interest to the payments industry because most of the recent FTC cases against processors have been based on this authority, where the FTC has essentially been able to go into court, get an injunction, and then try to hold the processors responsible for having in the past processed for fraudulent merchants and holding the processors financially liable to do consumer disgorgement for that. And that is being challenged right now. We're expecting a decision before the end of the term, so presumably in the next few months. And I think as Jonathan mentioned on that too, even if the FTC does lose its authority there, the FTC has some other options, and in particular, coordination with the CFPB as a way to follow up on that. Marijuana and CBD banking and payments, always a topic that gets a lot of attention. And the story seems to be the same kind of each year. Marijuana remains illegal under federal law, but with each election, more and more states legalize. The federal regulators have provided guidance that provides some guidance on how banks and financial institutions can serve the industry. And we're starting to see more and more slowly start to provide some services, but it continues to be something that very few banks are actually doing at scale. Hemp and CBD, on the other hand, are no longer controlled substances. So we're starting to see more payments companies provide services there. But again, it's still a complicated legal framework to deal with hemp and CBD. And so anybody that is getting into that area needs to do so pretty carefully. Next slide. In terms of prepaid card development, in early 2020, PayPal did sue the CFPB in a district court here in the District of Columbia, challenging some aspects of the CFPB's prepaid rule under the Administrative Procedure Act. In particular, the challenges were raised against the short form disclosure requirement and the requirement for a 30-day delay before the linking of any credit product to a prepaid account. In December, the district court issued an order basically granting PayPal's challenge and invalidating those two aspects of the prepaid rule, holding that really kind of going to the statutory language and doing the traditional APA type analysis, that the CFPB had exceeded its authority under the governing law to come up with those two requirements. I think that the general consensus is that it's very possible for the CFPB to appeal that decision, so it's something to keep an eye on. So with that, I would turn it over to my colleague Laura to talk about some of the charter issues that are particularly relevant to the payments industry.
Thank you, Andrew. So in his short run as acting comptroller of the currency, Brian Brooks was known for pushing the envelope, for instance, the fair access rule. But he also did a lot for payments, and that was really just building on the foundation set by comptrollers Curry and Otting. Remember that it was under Curry in the Obama administration that the Fintech charter was born. In recent testimony, he emphasized that, with respect to payments, it was important for the activity and not necessarily what charter it was attached to, but that the activity, give the company the ability, regulatory clarity, as well as a good structure, and then also bringing that activity into a comprehensive supervisory framework. He put together Payments Charter 1.0, which was very similar to Fintech, controversial, still out there, doing nothing. He's looked at digital activities, which the OCC is still considering, making sure that its regulations are in line. Just taking little steps to move payments companies towards some sort of regulatory clarity in terms of a charter. Interestingly, I would add, in December, Figure Technologies applied for a bank charter, not a fintech charter, but a national bank charter that would actually take deposits over $250,000 from accredited investors, and those deposits would not be insured, which seems to get around the issues that were created with the fintech charter. This bank would engage in lending, payments, and crypto activities. So with all that activity, what does that mean for the new administration? I think the fintech is here to stay, and moving, looking at the existing charters that are out there, and I think the options right there on that slide, and you can move on to the next slide and see what types of new payments companies are looking at these different charters. But taking the activity and fitting it into these charters until we can get some kind of clarity on the fintech charter. But the financial industry is moving forward with fintech. The fintech helps the financial inclusion, and there's a way to do it. And banks are showing that. Vero Bank chartering a full service bank. Companies like fintechs like GECO and Lending Club buying a bank. So you can get into it by either chartering the appropriate charter for you, or buying one and working within that charter.
Laura, thank you. And certainly the other option, of course, is just to buy a bank, and no shortage of people interested in that, and something we've seen a lot of questions on over the last year. Probably continue to see that. Now, Alex, there has been really a sea change after 7 years in the debt collection market. The CFPB finally last year, just at the end of the year, enacted new rules for debt collection that take effect at the end of this year in November. What does it all mean, and why is it important, not just for debt collectors, but also for creditors and anyone else in the debt and credit ecosystem?
Thank you, Jonathan. As Jonathan mentioned, this rulemaking has been 7 years in the making. It's gone through various stages, and the scope of it changed over the years. The rule that was issued at the end of 2020 was released in 2 parts. The first part in November and the second part in December. Both will go into effect on November 30th, 2021, giving the industry almost a year to enter into compliance. The rule ended up kind of addressing some of the lower hanging fruit, electronic communications and other communication provisions of the FDCPA, and clarifying some areas with respect to what must be in a validation notice and other disclosure requirements. Originally, the Bureau talked about potentially including substantiation and documentation requirements, meaning what level and what type of documentation a debt collector would need to have in possession in order to engage in certain collection activities. That was shelved and potentially will be addressed in the new CFPB under the Biden administration. The final rule covers debt collectors as that term is defined in the FDCPA. So if you were a debt collector before this rule went into effect under the federal statute, you still are. First party collectors, meaning creditors that are collecting in their own name, are not subject to the final rule. And it remains to be seen whether the CFPB will take up first party collections in a future rulemaking. But this rule does impact creditors in a number of ways. First, to the extent that creditor is working with, contracting with a debt collector, this impacts your oversight, vendor oversight and management program. Clearly, we'll need to understand the scope and requirements of the rule in order to ensure that your collectors are compliant with the law. It also requires cooperation between creditors and the debt collectors in order for the collectors to be in compliance. And so requiring additional information from creditors in order to engage in lawful collections. And so increasingly, creditors will be asked for more information. And then finally, the CFPB deliberately said that it will not opine as to whether or not the requirements and prohibitions in the rule could constitute a UDAP if committed by a non-debt collector, and that still could be the case. And so first party collectors, creditors are still subject to UDAP prohibitions under both the CFPB statute and also the Federal Trade Commission Act. Next slide, please. We have just a few slides kind of covering high level the requirements that will go into effect at the end of November of this year. The emphasis of the rule really was communications, how to interpret the FDCPA, which has dozens of specific sub-provisions that govern how a debt collector can communicate with consumers that owe the debt, but also third parties. So first, the final rule restates the FTC's prohibition relating to communications with consumers, but makes some clarifications, many of which the industry wanted to see, given lack of clarity over 40, 50 years. So first, if a consumer has requested that a debt collector not communicate via specific medium, meaning like email, then that must be honored. For industry to kind of sigh of relief, the Bureau made clear that text messages and email, other types of electronic communications are permissible and do not per se raise a risk of third-party disclosure, which was the original concern. And the rule does establish very specific procedures that an entity subject to the rule can raise in a bona fide error defense for unintentional violations. And so for both email and text message, there's a very, very technical framework built into the rule that requires debt collectors to ensure that the phone number or the email is actually tied to the person they're intending to contact in order to not be held liable for unintentionally disclosing information to a third party, which would violate the statute. Another area that, well, Jonathan, actually, you can go right back where we were. I just want to, the statute prohibits causing a telephone to ring or engage any person in a phone conversation repeatedly or consistently with the intent to annoy, abuse, or harass. That vague prohibition under the FDCPA has been interpreted by courts over the years. As a result, there's a patchwork of different requirements in different jurisdictions. The Bureau gave clarity. It has set a standard where a debt collector is presumed to be in violation of that call frequency requirement if it contacts a consumer more than 7 times within a 7-day period or within 7 days after engaging in a conversation with that person. So on the one hand, now we have a pretty black and white rule. On the other hand, it could be seen as pretty prohibitive. Important to note, calls with placed with consumers' consent do not count towards that limit. And so increasingly you're seeing framework that requires more give and take with the consumer. Social media was an area where concerns about disclosure to third parties or using kind of deception as a pretext to get to into a consumer's contacts, able to communicate with her over the years has been very scrutinized. The CFPB has clarified in this rule that it's okay to communicate over social media, but cannot post on someone's public wall or anything that can be seen by anyone else. And if you're going to seek access to someone's contacts, friend someone, you have to disclose that you're doing so as a debt collector. Finally, with respect to communications, whether to leave a voicemail was something that was always perplexing under the statute because of 2 separate prohibitions under the statute. One section of the statute said if you're going to make a communication, you have to disclose that it's by a debt collector and for the purpose of collecting a debt. A separate section of the statute prohibited disclosure of information about a debt to a third party. And so whether or not to leave a voicemail and how to do so presented the industry with a quandary, and the courts, of course, made it even more complicated. So to address that issue, the CFPB created a new term. It's a limited content message. If one leaves a message that has very limited content as set forth in the rule, it's not considered a communication, and therefore there's no risk that failure to disclose that it is a debt collection communication we know does not constitute a violation. There's also disclosure requirements in the new rule, much of which is consistent with what the statute already required. Some clarification. If a mini Miranda is provided in a written communication, then it doesn't need to be provided again. An area that we're seeing, not just on the federal level, but in local jurisdictions, is requiring disclosures to be in the same language that's used for the rest of the communication. So while we haven't seen any jurisdictions, including the CFPB, require debt collectors to translate into foreign languages communications with consumers, they are saying that if you're going to use a different language, then you have to make the legally required disclosures in that same language. And then with respect to the validation notice, which is built into the statute, the CFPB has made additional information required. So itemization of a debt, which is something that the statute didn't require, is now required in a validation notice. The CFPB has also said that if collectors include optional content or use their model template, then they can take advantage of a safe harbor. There are also some miscellaneous requirements on transferring debt. If a debt collector knows that a debt has been paid or settled or discharged in bankruptcy, it is unable to sell that account or transfer it for consideration. The CFPB did not expand that to other categories of debt like disputed accounts, et cetera, which is something that the proposed rule contemplated. The CFPB did not, well, it did kind of restate what has been accepted in common law, which is that debt collectors cannot file or threaten to file suit if a debt is time barred. What the CFPB did not do is go further and require that debt collectors essentially put a consumer on notice if her debt is past the statute of limitations, something that the FTC and CFPB have required in settlements with debt collectors over the years. So what's not in the rule? I just mentioned that the time barred notices and disclosures was not ultimately adopted. The rule also did not address legal collections, meaning what's required if the account's going to be sued on. Meaningful attorney involvement is a standard that the courts have massaged over the years with respect to what level of oversight and involvement an attorney must be in a lawsuit or in a collection activity that's going to lead to litigation in order to be not deceptive to label it as a threat to sue. But the Bureau did not go there. And finally, on e-sign, the CFPB did make clear that legally required disclosures like the validation notice must meet e-sign, but didn't stop for making that a further requirement in certain other areas. And so in sum, there's less than a year left for the industry to enter into compliance. Because of so much technicality around the safe harbors that the rule provides, it is something that's going to have to be carefully considered and implemented and trained on. I think many entities that are regulated here will be looking for systems to ensure compliance, and that requires a lot of tech, IT time, reprogramming, and testing to make sure it's working. And so expect to see a lot of activity from various vendors in this space. And of course, the next day, December 1st, 2021, expect to see supervision of compliance with this rule. And I think that will be something that will definitely be a priority under this administration.
Yeah, and Alex, there's been a lot of discussion as to whether or not the rule itself might be subject to a CRA, Congressional Review Act challenge, or some sort of rollback by the new bureau. But And none of us have a magic 8 ball, so we don't know exactly where that's going to land. But a lot of these provisions really relate to safe harbors for conduct that was in large part already permissible, perhaps risky, but permissible, maybe just not done by the industry. So it'll be interesting to see how that pans out. Obviously, we've talked about how that's something that we'll just have to wait and see. Something else that we know, though, is the case is really that first party collections, original creditors were not subject to the rulemaking, and they would have been subject to an original Part 2 of the Cordray era proposal. And even before that, it was supposed to be just a blunderbuss rule for everyone. So there's probably first party creditors, certainly if not in 2021, in the next 4 years of new CFPB, even with not the, on the agenda today, certainly a possibility. And it was something that's left open by the prior CFPB. And in the meantime, there's certainly the possibility for regulation through enforcement, which we saw in the Cordray era. So on supervision, examination, and enforcement, there is quite a lot to be said. A lot of it boils down to probably UDAP, UDAP, and UDAP. A lot of us have discussed, certainly there's no shortage of articles about the UDAP standard and how it was used in the Cordray era, and there's probably going to be a return to that. But I think before we talk about what the outlook looks like, it's important to consider actually what has happened in the past. And despite what anyone might write or say, it turns out that the CFPB has been quite active in investigations and also in enforcement through the supervision process, through exams over the last 2 years, and certainly even throughout the prior administration. But if you look, you see also too, and we can speak to this anecdotally, there are a lot of cases that are still pending, a lot of investigations that are still pending on the docket at various stages. And so there's really no shortage of activity in the pipeline. How they're dispensed with may differ, but even in the prior years, there were closing letters written, some investigations. In fact, in some cases, a large percentage of investigations were closed. Query, maybe they were sending out too many CIDs, but we're likely to see a return to an environment where they will ask questions and seek as much information as possible, as opposed to narrowly cast their net. Now, on supervision and examinations, Andy, I know that when you were at the Bureau, you headed up a lot of the training from a policy standpoint on substantive areas. From an exam standpoint, what would you expect folks to see different? At this point, a lot of folks have had their first round examinations, and in some cases 2 or 3, plus a COVID response exam.
Yeah, it's a good question. And ultimately it comes down to how much really changes on the supervision front. Obviously, enforcement may change quite a bit, but the supervision office has been largely run by the same people, as I think you were implying, throughout the last 2 years. And the CFPB hasn't become a light regulator in the examination context by any stretch. So I would expect to see a lot of the continued trends that we've seen. A few areas that I'd highlight that may be different. I touched on this earlier, but a renewed interest in student loan servicing. As we all know, the last few years there was an understanding between the Department of Education and the CFPB under Cranninger, really for the CFPB to back off, and that's unlikely to be the case, especially with Rohit Chopra, the former student loan ombudsman, and someone very, very close with Elizabeth Warren in charge of the Bureau. Fair lending, I also think, will be a key area where examinations will become much more rigorous, particularly in the mortgage space, but also in areas like indirect auto lending that fell off the last couple of years. That I expect to see more aggressive examinations in those areas, as well as just in fintech, to the extent that the companies are subject to CFPB supervision. You mentioned COVID, Jonathan. You're right. The companies that have implemented COVID relief have already largely started to go through examinations for their servicing practices and for their furnishing practices and so on. Many of them have done things well enough that it hasn't drawn a major investigation or an enforcement action to date, but things will be viewed through a different lens. I think and Allison can touch on this with enforcement. The communication between the supervision wing of the CFPB and the enforcement division, and how things like PAR letters are handled behind the scenes, probably will change with a more aggressive enforcement office. And certain areas like military lending, where the CFPB has backed off the last few years, will come back to the forefront. For COVID, I think servicing practices, particularly in the mortgage area, as they relate to ECOA and fair lending, will be important. I also think just UDAP. UDAP is a broad enforcement tool. It's also a supervision tool that the CFPB uses. And there's been a lot of ad hoc procedures put in place over the last year to deal with the pandemic that will be tested under a new administration.
And then when we've got on the enforcement side, there's certainly no shortage of areas of focus, all the ones we've talked about already today. But in addition to that, the pipeline will be relevant because we'll start to see a lot of these actions come to fruition, press releases issued, settlements entered into, maybe lawsuits filed in the current administration. And for the most part, those investigations, the early ones, announcements will have started in the Kraninger era. So as we saw from the statistics, there are CIDs out there. CFPB was not dormant. And interestingly enough, for all the rollbacks and changes and concerns on the part of the consumer groups, the reality is that the CFPB is fully functional and operational. None of the authorities around its ability to bring an enforcement action and to use UDAP, but for a policy position that's likely to be revoked, is at all affected from the activities of the last 4 years. And so what that really means is that UDAP will be front and center again, just as it was in the Cordray era. And civil money penalties and the ability for companies to settle for less than something that is the entire company or product line may be difficult. So, there's on one hand going to be a premium on compliance, but on the other hand, for companies that are smaller, have fewer than multiple product lines in areas that are not under investigation, when there is something that is under investigation, there's going to be a potential that the two sides can't meet on a resolution and for litigation. And when one is faced with that litigation prospect, the ability to marshal the facts, as well as also to deal with the issues related to the expansiveness of UDAP, will be critical. Technical compliance is also something too that will be relevant. But I think, as a capstone too, the enforcement process is one that has always been of interest. We have materials on our website on the enforcement process and the enforcement manual and other steps. It's always something that people don't want to delve into until they have to, but it is important to consider that exams, matters requiring attention, and other items identified can lead to enforcement as well. So it's not just something that is happens to someone else. It could happen to anyone who's under scrutiny. And that brings up an interesting point too. There are a lot of companies who are not under supervisory examination authority of the CFPB. And it's those organizations where the testing of compliance management systems and technical compliance with the law could very well be the focus of the Bureau going forward. We have a mature marketplace now. The idea of having a CMS and being examined for somebody who's a larger participant is not new. But for others, it may be. And it's worth noting too, one of the questions I got last week was, well, what should we do in face of all of this? And I made the comment, pull out all those old supervisory highlights where they were highlighting UDAP over and over again from the period of the Cordray era. Those are the things to look for, the connecting of the dots. And unfortunately, it's broad enough that they can bring allegations around facts that may not be front and center because of technical compliance, but rather because of areas related to consumer complaints, identifying perhaps systems or processes that are flawed, and then backing into issues. Simply having disclosures and meeting the definition of the individual consumer financial laws and the compliance checklist with those may not be enough. So to transition now into a brief look at the state landscape, Andy, no shortage of changes there. Probably the most notable are the mini CFPBs.
Yeah, it's an interesting development, especially in this time, because I think that the philosophy behind a lot of these mini CFPBs was the notion that the Bureau was being sidelined and was basically was receding as a law enforcer and as a consumer protection agency. And you've seen states like California, New York, and various others form their own mini CFPBs, really to carry the torch and to set a tone of strong consumer protection in those states that also, in many cases, happen to be the large states run by run by Democrats, where a lot of companies are based or really need to operate because they're massive marketplaces. Like I said, California and New York being the largest two. It will be interesting to see what happens on that front, because you really have seen, the slide here talks about California's DFPI. They actually have a division called the CFPD, which is very heavily based off of the CFPB. The DFPI is led by a CFPB alumni that Allison and I both worked with, and is very much modeled in its image and has a lot of the same authorities on the state level, including UDAP enforcement.
Right,
So,
and already launching investigations publicly of companies, naming them in a press release last week in the debt collection space. Perhaps a model to come where they'll just do industry by industry sweeps, essentially.
That's right, and I think it highlights a transition away from the old DBO, which was more of a licensing authority that had enforcement. It had some enforcement authority, but used it selectively, to something more like the CFPB. One of the things we saw when we were at the Bureau was a lot of coordination between the states and the agency, and that's probably going to continue. It has not been quite the same for the last few years. Probably will come back to where it was under the Cordray era, and I'll be interested to see how aggressive these state agencies are with the more aggressive CFPB. It does remain to be seen, but just because the CFPB is more aggressive or equally aggressive, depending on how you view it, doesn't necessarily mean that all of these Bureau alums that are in states are going to back off. They have their own citizens to protect. They have their own statutory and regulatory mandates to pursue.
And in just a moment, we will be giving the CLE code for today. So just a reminder for those that are looking for that. Hang tight, we'll be finished in a moment. But at this point, I'd like to ask our panelists to rejoin for the discussion in a moment. But Andy, back on states, something also too that's been happening is there's a shift in the multi-state licensing process and licensing in general, where it's becoming a lot more uniform relatively quickly, maybe not as fast as a lot of our clients would like, but all things considered, you're starting to see a lot more people gravitate to what arguably may be more efficient, but maybe not, the NMLS service, not just in mortgage, but also we're starting to see more scrutiny with licensing applications and exams too around that. Andy, can you speak a little bit to what you're seeing, particularly in the lending space?
Well, I guess it's a bit of a double-edged sword. The licensing process is more automated, more streamlined. You don't necessarily have to go to a police station in the precinct where you live and get fingerprinted and all of these various antiquated things that you've had to do in the past. But use of the NMLS system also provides a lot more transparency to the regulators. So any issues that you've had, any deficiencies that you've had, others can see. That has caused a lot of anxiety, so to speak. You can also see where else someone is licensed or not, and there's a lot of back office communication between these different agencies about companies that have applied for licenses and so on. So we've probably seen an overcorrection where companies are more likely to get state licenses, and even where they arguably don't need them, just get them anyway and get up and running and so on. But that's another area where I think it ultimately comes down to what sort of company are you, what sort of services are you providing, are you partnering with the bank and your story is we don't need to be licensed because we're a bank service provider, versus are you doing things under your own charter and authority? And that's I think an area that will continue to develop over the next few years.
Well, with that, again, we'll be giving the CLE code in just a moment, but I'd like to first, again, invite the rest of our panelists that are still on to join us for the closing questions and observations. Certainly, there's been no shortage of topics that we've discussed. There's many that we haven't, though. So with that, I'd like to go around and ask our presenters to comment on other items that maybe we haven't covered today, or just some additional thoughts, and then we'll do a wrap up. But first, Andrew, on payments or anything else, any observations and items you'd like folks to be aware of and think of?
Yeah, I mean, I think the thing that I would be thinking about if I was at a financial services company are kind of two things. One is looking backwards is to realize that, the enforcement agencies can still bring enforcement actions for conduct that happened several years in the past. So if you thought under the Trump administration with less regulatory oversight that you didn't have to worry about that, well, that may not be the case. And I think the flip side of that looking forward is that you might expect more examinations and supervision. So what you're doing now is also something that you need to be thinking about. So those are kind of the two things that I would be thinking about right now if I was in a compliance position.
And Sarah and Chris, on the legislative front, we talked a lot about how things could be bundled up in reconciliation. We also talked about the CRA, but I'd like to hear your thoughts a little bit more on congressional hearings. How might they coordinate with the agencies? I know, like, for instance, last week, there was a big to-do, Katie Porter not reappointed to the House Financial Services Committee. But, when I saw that, my initial thinking was as well, to the extent that she's known as being aggressive, maybe she's not going to be needed there because there'll be an aggressive CFPB. But that said, I'm sure House Financial Services is going to do plenty of hearings. What are you thinking in that regard?
Yeah, I'll take that one. Thanks it's a good question. I mean, just to your point, I was actually going to raise your first point about Katie Porter, and I was going to raise this in my comments. Tells you, I think, a little bit about the chair of the committee and really running that committee with an iron hand. And even though there's an aggressive, knowledgeable member who's junior, who was really not part of that team and a little less interested in that committee. So we are going to see a very aggressive and active, and the House was very active in its hearings. They obviously will have a different flavor with regulators where they will be, supporting instead of attacking. But what we will continue to see with these hearings is, they are really for show that reading the kind of prepared testimony is where you're going to learn most of the information, because the questioning does not say sustained and is not effective often very deep into the panels. I also would not expect coordination between the House and the Senate. While there will be sort of philosophical agreement now, and some hearings like the CFPB hearing and the monetary policy hearing appear kind of in the House and the Senate very quickly. I would not expect there to be kind of unity across the House and the Senate on the schedule of what they might have.
Thank you, Chris. Certainly an area to keep an eye on, and never fun to be the subject of a congressional investigation, particularly when you may be under supervision, exam, or have the specter of the regulatory agency also doing an investigation on whatever the topic of the day might be. So certainly we saw that in the Cordray area. We've seen that in situations when it was Democratic Congress, and could certainly see that in the future. So thank you. With that, certainly like to go around the horn with get some closing thoughts on items folks should be aware of and think about for compliance purposes. Obviously, we've talked a lot about things that are going to happen in the different spaces. A lot is interconnected, and certainly there's no shortage of comment on the change in tone and posture of the agencies too. So we'll go around the horn, and then folks stay tuned for the CLE code. Thank you. So Andy, we'll start with you. Final thought for 2021 outlook.
So a final thought, we didn't talk a lot about no action policies and the innovation office at the CFPB and so on, but I bring it up now just as a closing thought. There's been a heavy focus on innovation the last few years, and the CFPB supporting innovation and other regulators supporting innovation as well. We're probably going to see a shift back towards consumer protection. So as you are innovating, innovation is not going to stop. It's going to continue, and it should. But I think compliance and consumer protection are going to be all the more important. And, rather than getting out in front of things and having an investigation blow up, I think it's going to be critical to structure transactions in a way and to do due diligence and all these various things that you normally would do that, maybe haven't been as important the last few years as they will in the next few.
Laura?
Yes, following up on what Andy said, innovation will continue. Keep innovating. Look at the various charters out there. Be creative. Find something that works for you. Right now, it's sort of we're dealing with part regulatory turf war, part fear of big tech and giant retail. But keep moving it forward, and eventually, Congress will have to act. Not this year, but we're getting there.
Chris and Sarah.
I'm keeping my eye on the organizing resolution in the Senate to see if they'll cooperate, if there's going to be, if the Senate Democrats will work with Republicans on this and reach a mutual agreement. If they decide that they're going to go at this alone, I think that sort of tells us how they're going to go about pretty much everything in the Congress this session.
And Andrew. In 2021, we also have to remember that there's the mute button.
Yes, you think we'd have learned that lesson by now, but it's a new year. So I guess just maybe looking at an area that we didn't really touch on that I'm interested to see is, where does cryptocurrency go from here? It's not something we talked about. Is this going to be the year where it really starts to break out into some more retail or consumer-focused applications? Who knows? But there's certainly been some developments with Wyoming kind of taking the lead on the state level, and the OCC starting to issue more and more guidance as to how national banks can interact with this new technology. So I think it'll be interesting to see what happens with that.
And Chris?
I think it's worth noting and underlying Sarah's point that we are probably wouldn't expect a lessening of partisanship, and to keep in mind that no matter what happens, as we inevitably look ahead to politics and think about a shift of the House and the Senate, if that's possible, that the regulatory appointees will have a longer term impact and will be set before the next elections.
Indeed, we're less than 2 years from the next election as well. So with that, folks, my parting thoughts would be is compliance is going to be at a premium. There's no question. For the next 4 years, your fully functional compliance management system and the testing around that will be critical. In the Cordray era, there was a number of organizations that, for one reason or another, were building out their compliance management systems in parallel with being under intense scrutiny. Hopefully that's not the case now. Hopefully those are up and running. There's been probably at least one look-see if you're subject to examination. And as a result of that, the functional compliance management system will serve a very important purpose. And that's not just a snapshot in time, but that's day in and day out. And as designing new products and services continues, incorporating those into the CMS with respect to compliance, as well as also legacy products and services, will be critical. And of course, in an examination or an investigation, the ability to marshal your facts will be extremely important, given the broad authority that the agencies, in particular the CFPB, has. So with that, this is Consumer Financial Services Outlook 2021. I'd like to thank all of my panelists, as well as also you, the attendee, for attending today, as well as also our support team here at Venable. With that, we will conclude our session and provide the CLE code in just a moment. And today's CLE code is Outlook 2021. Again, the CLE code is Outlook 2021. Thank you.